What type of information is a liquidator entitled to after their appointment? So I want to start with the situation that liquidators find themselves in. Routinely, they're in a position where they're needing to reconstruct the books and records of the company. They weren't there at the time of the insolvent trading. They weren't there when contracts were signed. They don't understand what each and every transaction in the bank account represents. So they need to reconstruct a huge volume of financial records. So with that in mind, Parliament gave liquidators some quite extraordinary powers to collect information. They can go to your lawyers. They can say, give me all of the files. They can go to accountants and say, give me all of the files. So just put that into perspective. You're a company director. You weren't anticipating a liquidation. You're having very private conversations with your lawyer. They could be emails. They could be file notes or phone calls that you expected to be privileged and confidential, but the company was the client. The liquidator will go and get all of those records and probably use it against you, particularly if they say you breached your duties and maybe you were talking to your lawyers or accountants about that. Maybe there's a silver bullet in those communications, and that's usually where the silver bullet is. So if the company is the client, I would be thinking about restructuring that engagement as a personal engagement, particularly if you're dealing with insolvency-related issues. Need to look at it through the lens of who is going to gain access to this information after the event. The other thing they're going to do is they're going to go to the banks and they're going to collect all of that information as well to help reconstruct. Where liquidators often overstretch is they will go to creditors and they will say, give me all of your communications with the company, give me all these records that relate to the company. Now, whilst they might relate to the company, they're not books and records of the company. And that distinction is really important. And often what I see is creditors giving up information that liquidators weren't even entitled to receive, and then liquidators using that information against creditors when it comes to voidable transactions and transactions under value. And it's all well and good when the liquidator's being friendly, but once they have the information, it'll be a very different story. So if you get one of these types of requests, and it's a request under Section 261 of the Companies Act, really important to just pass that by a specialist lawyer just to make sure that it's the type of information that liquidators are entitled to receive.